An Oakville man who won a lawsuit for a slip and fall accident says he's shocked that he had to pay $55,000 for his lengthy hospital stay. Guy McMurray said he was in excruciating pain for months after he slipped and fell on black ice in front of his workplace in 2013, smashing his kneecaps and severing his tendons. He describes the accident.
As I'm leaving my office, I slipped on black ice. I landed square on my kneecaps and smashed my kneecaps and severed all my tendons.
Took him 80 days to recover in the hospital, and he said he had an allergic reaction and his heart stopped. Well, when he received the award of $350,000 in 2014, he filed a lawsuit in 2014. He was eventually awarded $350,000. He said Ohip asked him to hand over $55,000.
But I had no idea that Ohip was going to be involved in this claim process at all. They had no part of my extreme discomfort. They don't really care. They just wanted money from my claim.
He feels like Ohip is double dipping because he pays Ohip as a taxpayer, and Ohip is then reaching in when he receives a settlement and taking $55,000 of that money. We had never heard of this before, wondering how common it is or not. So we invited our friend and personal injury lawyer, Jasmine Daya, onto the show. Hi, Jasmine. Welcome back.
Hi, Barb. Thanks for having me.
I should say managing principal of Jasmine Daya & Co. And is this something that is common with personal injury law?
It is, and it's required by law, but there is a little bit of a misleading situation here that we should clarify. So, if you have a personal injury lawsuit arising from any claim except a motor vehicle accident, so a car accident, then OHIP has a right of subrogation. That means that OHIP can claim from the responsible party to recoup what they've had to pay for in terms of services they've provided to the injured person.
Okay, so should that always be explained to the plaintiff?
Absolutely. And that's where things get a little bit messy in this situation, because when I have a client come in, what I tell them in my first meeting is what they are entitled to sue for. So there's different damages that you sue for. For example, your pain and suffering, any income losses, any medical costs that are not covered through OHIP. Those are all things we sue for. Separately, as the lawyer of the injured party, I am required under the law to also represent OHIP's interests. So I have to sue for OHIP also. And it's a separate line item, and it needs to be explained to the client. So in this situation, the reason I say it's a bit misleading is because it's not actually coming from the claimant's portion. It's a separate line item. And so the lawyer, the plaintiff's lawyer, so the injured party's lawyer, should be advancing claims for the injured party as well as for OHIP, and should clearly be outlining what is for what to their client.
Sure, so that the client doesn't end up thinking, well, I got $350 and OHIP is taking $55,000. They should think, well, I got $295 and OHIP got $55,000 or whatever the case may be, right?
Exactly. And there's a complete list. So there's something that the Ministry of Health will provide called a payment summary. And the payment summary outlines all the associated costs that were billed to OHIP in relation to the incident that you've sued for. And oftentimes, I will look at the payment summary, and if there seems to be a few things that don't add up that may not be related to the claim, I will provide a copy of that payment summary to my client to look at with me and say, hey, does anything stand out to you that doesn't seem related? And sometimes there are a few things. So we can tell OHIP, hey guys, this does not relate to the personal injury lawsuit, and they'll take that amount out.
As a lawyer, I'm asking, you must by law sue on behalf of OHIP for that portion. So it's not like that you have a choice in it. You have to do that?
That's right. Section 31 of the Health Insurance Act in Ontario creates a solicitor and client relationship between the claimant's lawyer and OHIP. So I have to notify OHIP. And in fact, if I don't, that could be hugely problematic to my client as well as to me. So at the outset, when I first am retained, I put OHIP on notice that means that I send a letter to OHIP saying, I have this claim, I'm suing on behalf of this individual. Please let me know what the associated costs are. And they'll continue to send me updates. If I don't do that and I settle a claim without settling OHIP's amount, OHIP can come after my client for non-payment, and my client will come after me, their lawyer, for not protecting them. So I want to make sure that I am protecting the client and ensuring that there is recovery with OHIP.
We don't know what happened here, but could that have happened, that the lawyer did not sue for OHIP's portion and OHIP came after to get the money from the settlement?
No, I think that OHIP was involved because OHIP usually would not, you wouldn't see the line item there. They would come up to the individual or to the lawyer much later. So they were definitely involved, but it just seems like a situation where the individual wasn't explained all the details by the lawyer and what the meaning of these amounts were. There's another aspect to this that we can talk about also, which is that although OHIP's bill is X, you might pay Y.
Jasmine Daya is on the line with us, personal injury lawyer. And Jasmine is saying not only is this common, this is required by law that the lawyer has to sue on behalf of not only the client, but OHIP as well. And perhaps, Jasmine, as one texter suggested, perhaps the lawyer wasn't great or the client wasn't listening to the lawyer when the lawyer explained all of the different parts.
That's possible too, and I know that with a lot of clients who come in when they're first injured and they are meeting with a lawyer for the first time, there's a lot of information to absorb. So perhaps it was a situation where the lawyer did explain and the individual did not retain that information at the outset. Usually, however, there's different times along the way of a proceeding, whether it's through mediation or settlement discussions, where that conversation, it occurs again, and you remind the client OHIP has a right to subrogate.
And what was the point you were making before we broke? Because I want to make sure to get that, and then I've got some callers on the line.
What I was saying is I'd expressed it in a way that sometimes OHIP will be seeking X, but you'll pay Y. So I'm going to give you an example because it makes more sense that way.
Okay.
If you have a slip and fall incident, so you're walking along, it's icy conditions, you end up falling and sustaining an injury. Perhaps you fracture your leg, for example. OHIP might say, well, we have a bill of $10,000, and so we want to recover $10,000 from this lawsuit. When you're in the lawsuit, there might be an allegation of contributory negligence. So the defense, the people we've sued, the property owner, for example, they might say, well, your client was wearing high heels in icy conditions, and that contributed to the fact that they fell and sustained an injury. So we want to reduce how much we pay you for your claim for pain and suffering. So if there is a reduction in that scenario of, let's say, 20%, so whatever you get for your pain and suffering is reduced by 20%, you would go to OHIP as their lawyer, as the claimant's lawyer, and say to OHIP, look, there is a contributory negligence allegation. There should also be a 20% reduction on your bill and your amount that you're seeking to recover. And OHIP will usually agree as long as you provide them with proper reasons.
Okay, that makes perfect sense. Jasmine Daya, thank you very much for this.
Oh, it's my pleasure.
Personal injury lawyer, managing principal of Jasmine Daya & Co. Jasmine.